Good morning, everyone. This is Russell Rucker, and I'm here for another constitutional talk. And with habeas corpus recently in the news, I thought we go through the constitutionality of this. Um, Habeas corpus, is roughly translated, is he has the body. But if you go to Article 1, um, Section 9 of our Constitution. This is the section, Article 1, that has to do with Congress, and it's in this section. Okay. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So, what is a writ of habeas corpus? Well, it's basically a note or a letter telling the judge that you want review of your confinement or internment. So if they're holding you somewhere and you think it is unjustified, then you can ask the judge for a review of that confinement. So, in other words, if you're under arrest and you're sitting in a cell, you can ask for a writ of habeas corpus to review whether or not you should have been confined. Now, there are a couple of cases here, a couple of examples they give, like in cases of rebellion or invasion, where public safety is concerned. Now, the whole idea of public safety being reviewable is just basic judicial philosophy to begin with. You need to make rulings that are based in public safety. Rulings, so when you make a ruling, it is housed in public safety. For instance, you cannot release somebody pre-trial that is accused of several murders, for instance, because the public safety could be viewed. You also can't have a decision that you make that is so outside public safety that others could be hurt by your decision. This is just simple, basic judicial philosophy. And most judges are taught that you have to relegate your decisions in public safety. So here we have this exception, you know, in a riot, for instance, an invasion. Um, Things obviously are not going well, and we must have some semblance of safety. So is this place where you can suspend the writ of habeas corpus. But generally speaking, we're not allowed to do so. Now, when you look at habeas corpus and the writ of habeas corpus, it comes to us from Old British common law, actually from the 17th century in Britain. So this goes back a long ways. And the writ of habeas corpus and presidential authority to pardon and a governor's authority to pardon, along with the Fourth through Eighth Amendments, your right of a speedy trial, your right against self incrimination. All these rights encompass the rights of the accused, and the writ of habeas corpus is no different. It just gives you a possibility to appeal your confinement. And what would happen is this would be reviewed by a judge, and he would make a decision whether or not your confinement was legitimate. I hope you have a little better understanding of this. Whether or not it's advisable to suspend it is a whole nother argument. It would have to be a very serious situation for one to do so. I hope you get a better understanding of what it is, and we'll catch you next time on the next Constitutional Talk. Liberty is so important. It is so vital, my friend. And to be denied liberty is very serious. And this is another chance of having a review of your case. Please subscribe to me, follow me, and we'll catch you next time, next week, on the next Constitutional Talk. You folks have a good day for now. Bye.